CPC Institution of Suit. Section 26 to 35B. Orders 1 to 20 of the first schedule deal with the procedure relating to suits. Order 1, 2 and 4 provide for parties to suit, frame of suit and institution of suit. Suit, meaning the term suit has not been defined in the code. According to dictionary meaning, suit is a generic term of comprehensive significance, referring to any proceeding by one person or persons against another or others in a court of law, wherein the plaintiff pursues the remedy which the law affords him for redress of any injury or enforcement of a right, whether at law or in equity. Ordinarily, a suit is a civil proceeding instituted by presentation of a plaint. Essentials of a suit. There are 4 essentials of a suit: opposing parties, subject matter in dispute, cause of action, and relief. Parties to suit. Order 1. General. Order 1 deals with parties to a suit. It also contains provisions for addition, deletion, substitution of parties, joinder, misjoinder, non-joinder of parties, and objection as to the misjoinder and non-joinder. It is also to some extent deals with the joinder of causes of action. A provision is also made for representative suit. Plaint, meaning the term plaint is not defined in the code. It may, however, be described as a private memorial tendered to a court in which the person set forth his cause of action, the exhibition of an action in writing. Joinder of parties. The question of the joinder of parties may arise either as regards the plaintiff or as regards the defendants. An act may be done by a single individual or may adversely affect another individual. In that case, the question of joinder of parties does not arise at all. Thus, where A assaults B and the latter may sue A for tort as it individually affects him. The question of joinder of parties arises only when an act is done by 2 or more persons or it affects 2 or more persons. Thus, if A assaults B and C, or A and B assault C, the question of joinder at plaintiffs or defendants arises. Joinder of plaintiffs. Rule 1. Rule 1 provides for joinder of plaintiffs. It states that all persons may be joined in one suit as plaintiffs if the following 2 conditions are satisfied. The right to relief alleged to exist in each plaintiff arises out of the same act or transaction, and the case is of such a character that if such persons brought separate suits, any common questions of law or fact would arise. Both or above conditions should be fulfilled. The primary object of Rule 1 is to avoid multiplicity of proceedings and unnecessary expenses. Illustrations. Illustrations. A enters an agreement jointly with B and C to sell 100 tins of oil. A thereafter refuses to deliver the goods. Here both B and C have each of them a right to recover damages from A. The said right arises out of the same transaction, namely the breach of agreement, or common questions of law and fact would arise. B and C therefore may file a suit jointly as plaintiffs against A for damages. An altercation takes place between A on the one hand and B and C on the other. A assaults B and C simultaneously. B and C may join as plaintiffs in one suit for damages against A for that tortious act, since both the above conditions are fulfilled. A agrees to sell and deliver 100 tins of oil to B at a particular rate on 1st January 1991. He also agrees to sell and deliver a like quantity of oil on the same day at the same price to C. B and C cannot join as plaintiffs in one suit as A as the transaction are different. Joinder of defendants. Right 3. Rule 3 provides for joinder of defendants. It says that all persons may be joined in one suit as defendants if the following conditions are set. The right to relief alleged to exist against them arises from the same act, and the case is such character that if separate suits were brought against such persons, any common question of law or fact would arise. The word "and" makes clear that both the conditions are cumulative and not alternative. The underlying object of Rule 3 is to avoid multiplicity of suits and needless expenses. Illustrations. There is a collision between a bus and a car. The bus belongs to B and the car belongs to C. As a result of the collision, A passerby, is injured. A may join B and C as defendants in one suit for damages for injuries caused to him by negligence on the part of both of them or any of them, since the case involves the common questions of the fact arising out of the same act, namely collision of 2 vehicles. An alternation takes place between A on the one hand and B and C on the other. B and C simultaneously assault A. A may join B and C as defendants in one suit for damages or for the tortious act as both the above conditions are fulfilled. B, C, D and E each separately entered into an agreement with A to supply 100 tins of oil. They failed to supply the goods. A cannot join B, C, D and E as defendants in one suit for damages inasmuch as there are 4 distinct contracts and therefore 4 different transactions. The plaintiff may join in one suit all or any of the persons severally or jointly and severally liable in any one contract. Similarly, where the plaintiff is in doubt as to the person from whom he is entitled to obtain redress, he may join 2 or more defendants in one suit. Where it appears to the court that any joinder of plaintiffs or defendants may embarrass or delay the trial of the suit, it may pass an order for separate trials. Similarly, the court may give judgment for one or more of the plaintiffs as may be found entitled to relief against one or more of defendants as may be found liable. Necessary and proper parties. There is an essential distinction between a necessary party and a proper party to a suit. A necessary party is one whose presence is indispensable to the constitution of the suit, against whom relief is sought, and without whom no effective order can be passed. A proper party is one in whose absence an effective order can be passed, but whose presence is necessary for a complete and final decision on the question involved in the proceeding. In other words, in the absence of a necessary party, no decree can be passed. While in absence of a proper party, a decree can be passed so far as it relates to the parties before the court. His presence, however, enables the court to adjudicate more effectively and completely. 2 tests have been laid down for determining the question whether a particular party is a necessary party to a proceeding. There must be a right to some relief against such party in respect of the matter involved in the proceeding in question, and it should not be possible to pass an effective decree in the absence of such a party. Thus, in a suit for partition, all sharers are necessary parties. Similarly, a purchaser of property is a public auction is a necessary party to the suit for declaration as to set aside and the said public auction. Likewise, in an action against selection of appointment by an authority, candidates who are selected and appointed are directly affected and therefore are necessary parties. On the other hand, a subtenant is only a proper party in a suit for possession by the landlord against his tenant. So also, grandsons are proper parties to a suit for partition by sons against their father. Likewise, a local authority for whose benefit land is sought to be acquired by the government is a proper party in the land acquisition proceedings. Again, in a complaint against a seniority list prepared by an employer, if no relief is sought against the particular individual, the person shown as senior to the petitioner or the plaintiff are proper parties. But if relief is claimed against a specific person, he is also a necessary party to the proceeding. It may however be noted that where several persons are interested in a suit, it is not always necessary that all of them should be joined as plaintiffs or defendants. Rule 8 of Order 1 applies to such suits, and it is sufficient if some of them are joined as plaintiff or defendants as the case may be. Non-joinder or misjoinder of parties. Rule 9. Where a person who is a necessary or a proper party to a suit has not been joined as a party to the suit, it is a case of non-joinder. Conversely, if 2 or more persons are joined as plaintiffs or defendants in one suit, and in contravention of the Order 1, Rule 1 and 3 respectively, they are neither necessary nor proper parties. It is a case of misjoinder of parties. The general rule is that a suit cannot be dismissed only on account of non-joinder or misjoinder of parties. Nor a decree be passed by a competent court on merits will be set aside on the ground of misdescription of the defendant. However, this rule does not apply in case of a non-joinder of a necessary party. If the person who is likely to be affected by the decree is not joined as a party in the suit or appeal, the suit or appeal is liable to be dismissed on that ground alone. But in B. Prabhakar Rao versus State of AP, where all the affected persons had not been joined as parties to the petition, and some of them were joined, the Supreme Court took the view that the interest of the persons who were not joined as parties was identical with those persons who were before the court and were sufficiently and well represented, and therefore the petition was not liable to be dismissed on that ground. Similarly, no decree or order under Section 47 of the Code can be reversed or substantially varied in appeal, inter alia, on account of any misjoinder or non-joinder of parties not affecting the merits of the case or the jurisdiction of the court, provided such party is not a necessary party. Objection as to non-joinder or misjoinder of parties. Rule 13. All objections on the ground of non-joinder or misjoinder of parties must be taken at the earliest opportunity, otherwise they will be deemed to have been waived. But if the objection as to non-joinder of a necessary party has been taken by the defendant at the earliest stage and the plaintiff declines to add the necessary party, he cannot subsequently be allowed to appeal to rectify the error by applying the amendment. Striking out, adding or substituting parties. Rule 10. Rule 10.1 of the Order 1 deals with striking out, addition or substitution of parties, adding or substituting plaintiffs. If after filing of the suit the plaintiff discovers that he cannot get the relief he seeks without joining some other person also as a plaintiff, or where it is found that some other person and not the original plaintiff is entitled to the relief as prayed for, an application for addition or substitution of plaintiff can be made. The object underlying this provision is to save honest plaintiffs believing bona fide in the maintainability of their claim being non-suited on a mere technical ground. In other words, the policy is to decide the real questions in controversy between the parties, bypassing the mere technical objection for defeating a just and honest claim by discouraging puerile contest or technicalities. The provision therefore must be liberally construed as to advance the cause of justice. To bring a case within this sub-rule, the following three conditions must be satisfied. The suit has been filed in the name of a wrong person as plaintiff. Such mistake must be bona fide, and the substitution and addition of the plaintiff is necessary for determining the real matter in dispute. Illustrations. C. The agent of A, under bona fide mistake, files a suit against B in his own name. The court can substitute the name of the principal A for that of the original plaintiff C. A joint Hindu family firm files a suit under bona fide mistake in the name of the firm, although the provisions of Order 30 relate to filing of suits by firms do not apply to such a firm. The court may allow substitution of the names of the members of HUF as plaintiffs. A, claiming a title under a deed, files a suit for possession of a house against B under a bona fide mistake that the house was gifted to him by the said deed. When it was found that the deed did not pertain to that house, the real owner could be substituted as a plaintiff in place of A. A sues B for possession of a house. B contends that since A has transferred the house to C, he has no title to sue and the suit is therefore not maintainable. A maintains his right, contending that no transfer was made, but the contention is found to be false. Thereupon, A applies for adding case as a C as a co-plaintiff. The application requires to be rejected, since the mistake was not found to be bona fide. Such amendment may be allowed by the court at any stage of the suit or even at the appellate stage upon set terms and conditions as it thinks fit. No person can be added as a plaintiff without his consent. Striking out or adding parties. Sub-rule 2 of the Rule 10 empowers the court to add any person as a suit on either of the two grounds. Such person ought to have been joined as a plaintiff or a defendant and is not so joined, and without his presence the question involved in the suit cannot be completely decided. The purpose of this provision is to bring before the court at the same time all the persons interested in the dispute, so that the dispute may be finally determined at the same time in the presence of all the parties without delay, inconvenience and expense of several actions and trials of inconclusive adjudications. This provision thus confers wide discretion on the court to meet with every case of defect of parties and is not affected by the inaction of the plaintiff to bring the necessary parties on record. Addition of parties is, however, a judicial discretion which is required to be exercised judiciously. Power and duty of court. Provisions of Rule 10 Clause 2 of Order 1 confer very wide powers on the court regarding joining of parties. Such powers have to be exercised on sound judicial principles, keeping in mind all the facts and circumstances of the case. Two considerations especially will have to be kept in mind before exercising the powers: that the plaintiff is a dominus litis, he is the best judge of his interest. It is therefore for him to choose his opponent from whom he claims relief, and normally the court should not compel him to fight against a person whom he does not want to fight and from whom he claims no relief. And if the court is satisfied that the presence of a particular person is necessary to effectively and completely adjudicate all the dispute between the parties, irrespective of the wishes of the plaintiff, The court may exercise the power and join a person as a party to the suit. The power may be exercised by the party at any stage of proceedings, either upon an application of the parties or even suo motu of its own motion, and on such terms and conditions may appear to the court to be just. In Anil Kumar versus Shivnath, considering the provision of Order 1, Rule 10.2, Supreme Court observed that though the court may have power to strike out the name of the party improperly joined or add a party either on application or without application or of either party, but the condition precedent is that the court must be satisfied that the presence of such party to be added would be necessary in order to enable the court to effectually and completely adjudicate upon and settle all the questions involved in the suit. The object of the rule is to bring the record all persons who are parties to the dispute relating to the subject matter, so that the dispute may be determined in their presence, at the same time without any protraction, inconvenience, or to avoid multiplicity of proceedings. Thus, if a special statute makes a person necessary party to the proceeding and also provides that non-joinder thereof will result in dismissal of the petition, the court cannot use the curative powers of Order 1, Rule 10 to avoid consequences of non-joinder of such person. Test. The test is not whether the plaintiff agrees or objects to the addition of a party to the suit, but whether the presence of such party is required for full and complete adjudication of the dispute. Principle. Suffice it to say that in the leading case of Razia Begum versus Shehzadi Anwar Begum, the Supreme Court has laid down the following principles regarding the power of the court to add parties under Rule 10.2 of the Code. The question of addition of parties, Rule 10.2 Order 1 of the Civil PC, is generally not one of initial jurisdiction of the court, but of a judicial discretion which has to be exercised in view of all the facts and circumstances of a particular case. But in some cases, it may raise the controversies as to the power of the court in contradistinction to its inherent jurisdiction, or in other words, of jurisdiction in the limited sense in which it is used in Section 11 of the Code. That in a suit relating to a property, Section 115 of the Code, that in a suit relating to a property, in order that a person may be added as a party, he should have a direct interest as distinguished from a commercial interest in the subject matter of litigation. Where the subject matter of a litigation is a declaration as regards the status of a legal character, the rule of present or direct interest may be relaxed in a suitable case where the court is of the opinion that by adding that party it would be in a better position to effectually and completely adjudicate upon the controversy. And the cases contemplated in the last proposition have to be determined in accordance with the statutory provisions of Section 42 and 43 of the Specific Relief Act. In Razia Begum versus Anwar Begum, A sought a declaration that she was legally wedded wife of B. One C claimed to be another married wife of B and sought to be added as a party defendant. The prayer was granted since the declaration sought for the concerned status of marriage and legitimacy of children and would affect the parties for generations to come. Thus, the test is not whether the plaintiff agrees to adding a party as a defendant or not, but whether the relief claimed by the plaintiff will directly affect the intervener in the enjoyment of his rights. The court must in every case record reasons in support of it in order of impleading or refusing to implead a party. But the party cannot be added so as to introduce a new cause of action or alter a new cause of action or to alter the nature of the suit. Power can be exercised by the court at the stage of trial and that too without prejudice to the said party's plea of limitation. Rule 10A enables the court in its discretion to request any pleader to address as to any interest likely to be affected by its decision, if such party is not represented by a pleader. Reference may be made to a decision of the Supreme Court in Ramesh Hirachand versus Municipal Corporation of Greater Bombay. In that case, the plaintiff was a dealer on land held by Hindustan Petroleum Corporation lessee and was in possession of a service station. The Municipal Corporation issued a notice to the plaintiff for demolition of a certain construction, alleging that it was unauthorized. The plaintiff filed a suit for permanent injunction against the Municipal Corporation. Hindustan Petroleum Corporation applied for being impleaded as a party defendant on the ground it had material to show that the structure was unauthorized. The prayer was granted by the courts below. The plaintiff approached the Supreme Court. Allowing the appeal and setting aside the order, Supreme Court held that the Hindustan Petroleum Corporation was neither necessary nor a proper party. to the proceedings. The person to be joined must be the one whose presence is necessary as a party. The test is not whether his presence is necessary for the correct solution of the dispute before the court, but whether the order would affect him or his interest would be prejudiced. In the instant case, the question before the court was whether any unauthorized structure was made by the plaintiff contrary to Bombay Municipal Corporation Act, and not whether such construction was contrary to the agreement between the plaintiff and HPCL. It was altogether a different cause of action. The mere fact that a fresh litigation can be avoided is no ground to invoke the power under rule. In such cases, the court rightly stated, it cannot be said that the main object of the rule is to prevent multiplicity of actions, though it may incidentally have that effect. It is therefore necessary that the person must be directly and legally interested in the action in the answer. That is, he can say that the litigation may lead to a result which will affect him legally, that is, by curtailing his legal rights. It is difficult to say that the rule contemplates joining as a defendant a person whose only object is to prosecute his own cause of action. The court is also authorized to strike out any party improperly joined either as a plaintiff or a defendant in a suit. Effect: where any person is added as a defendant in a suit, as regards him, the suit shall be deemed to have been instituted from the date he is joined as a party. Where a defendant is added, the plaintiff shall be amended, and amended copies of the summons and plaint must be served on the new defendant. Transposition of parties. In transposition, a person who is already on record as a plaintiff or a defendant seeks his transposition from one capacity to another capacity, that is, from plaintiff to defendant and vice versa. Since the primary object of the Order 1, Rule 10 of the Court is to avoid multiplicity of proceedings, there is no reason why the doctrine of addition or striking out parties does not apply to transferring the parties from one side to other side. A court can therefore order transposition of parties in an appropriate case. This can be done either on application by a party or by a court suo moto. No such transposition, however, can be allowed if it alters the character of the suit or causes prejudice to the opposite party. Representative suit. General. As a general rule, all persons interested in a suit ought to be joined as parties to it, so that the matters involved therein may be finally adjudicated upon and fresh litigations over the same matter may be avoided. 55 Rule 8. Rule 8 reads thus. 8. One person may sue or defend on behalf of in the same interest. 1. Where there are numerous persons having the same interest in one suit, one or more of such persons may, with the permission of the suit, sue or be sued or may defend such suit on behalf of or for the benefit of all persons so interested. The court may direct that one or more of such persons may sue or be sued or may defend such suit on behalf of or for the benefit of all the persons so interested. The court shall, in every case where a permission is given under Sub-Rule 1 at the plaintiff's expense, give notice to the institution of suit to all persons so interested, either by personal service or by reason of a number of persons or avoided. Rule 8 is an exception to this general principle. It provides that when there are a number of persons similarly interested in a suit, one or more of them can, with the permission of the court or upon direction of such court, sue or be sued on behalf of themselves and others. The plaintiff in a representative suit need not obtain the previous consent of the persons whom he seeks to represent. Definition. The representative suit may be defined as under. A representative suit is a suit filed by or against one or more persons on behalf of themselves and others having the same interest in the suit. Object underlying this provision is really to facilitate the decision of a question in which a large number of persons are interested without recourse to the ordinary procedure. Order 1, Rule 8 of the Code has been framed in order to save time and expense, to ensure a single comprehensive trial of question in which numerous persons are interested, and to avoid harassment to parties by a multiplicity of suits. In cases where the common right or interest of a community of members of an association or a large section is involved, there will be inseparable in other cases. In any other cause, such service is not reasonably practicable. By public advertisement, as the court in each case may direct, any person on whose behalf or for whose benefit a suit is instituted or defended under Sub-Rule 1 may apply to the court to be made a party to the such suit. No part of the claim in any such suit shall be abandoned under Sub-Rule 1, and no suit shall be withdrawn under Sub-Rule 3 of the Rule 1. Order 23. or no agreement, compromise or satisfaction will be recorded in any such suit under Rule 3. Unless the court has given at the plaintiff's expense notice to all the persons so interested in the manner specified under Sub-Rule 2. No compromise. As a rep. Where any person suing or defending any such suit does not proceed with due diligence, the court may substitute in his place any other person having the same interest in the suit. A decree passed in a suit under this rule shall be binding on all persons on whose behalf, for whose benefit the suit was instituted and defended, as the case may be. Explanation. For the purpose of determining whether the person who sue or are sued or defend have the same interest in one suit, it is not necessary to establish that such persons have the same cause of action as the person on whose behalf or for whose benefit they sue or be sued or defend the suit, as the case may be. Practical institution under the ordinary procedure where each individual has to maintain an action by a separate suit. To avoid numerous suits being filed for a decision of the common question, Order 1, Rule 8 has come to be enacted. The provision therefore should receive literal interpretation which will subserve the object of its enactment. To bring a case within the provisions of Order 1, Rule 8 of the CPC, all members of a class should have a common interest in a subject matter. Common interest. And the relief sought should in its nature be beneficial to all. Order 1, Rule 8 of the CPC's enabling provision does not compel anyone to represent many if by himself he has a right of suit. The rule does not vest a right of suit in a person if he by himself has no right to sue. He cannot proceed to sue on behalf of others by invoking the aid of the Order 1, Rule 8 of the CPC. At the same time, Order 1, Rule 8 of the CPC does not debar a member of a village community from maintaining a suit in his own right in respect of a wrong done to him through the act complained of may also be injurious to some other villagers. Enabling provision. Order 1, Rule 8 of the Code is merely an enabling provision. It, however, does not compel an individual to represent body of persons having the same interest if his action is otherwise maintainable, joining the rest in a suit. In other words, it does not debar a member of a community from maintaining a suit in his own right in respect of the wrong done to him. Conditions. For the rule to apply, the following conditions must exist. The parties must be numerous and they must have the same interest in the suit, and the permission must have been granted or direction must have been given by the court, and notice must have been issued to the parties whom it is proposed to represent in the suit. Numerous persons. The first requirement for the application of Rule 8 is that numerous persons must be interested in the suit. The word numerous is by no means a term of art. It does not fix any limit to the number. It is not synonymous with the word numberless or innumerable. It has an ordinary meaning implying a group of persons. Therefore, the question whether parties can be said to be numerous must be decided by the court upon the facts of each case, taking into account the nature of controversy and the subject matter in dispute and so on. It is, however, not necessary that the number of persons should be capable of ascertainment, but it is necessary that the body of persons represented by the plaintiffs or defendants must be sufficiently definite so as to enable the court to recognize as participants in the suit. Thus, a representative suit on behalf of the inhabitants of a village with reference to the village property or on behalf of members of a sect, caste or community is maintainable under this rule. Same interest. The second requirement for the maintainability of the representative suit is that the persons on whose behalf a suit is instituted must have the same interest. One is numerous. Second is same interest. The second requirement for the maintainability of the representative suit is that the persons on whose behalf the suit is instituted must have the same interest. The interest must come to them all, and they must have the common grievance which they seek to get redressed. Community of interest is therefore essential. It is a condition precedent for bringing a representative suit. The interest need not be a proprietary one, nor need it be a joint or concurrent, as explained by Lord Macnaghten in Duke of Bedford versus Ellis. Given a common interest and a common grievance, a representative suit was in order if the relief sought was in the nature beneficial to all whom the plaintiff proposed to represent. Thus, where a person dies leaving numerous creditors, any one of them may sue on behalf of himself and other creditors, or any one taxpayer may file a suit against a municipality on behalf of himself and other taxpayers to restrain the municipality for misapplying its funds. The explanation added by the Amendment Act of 76 clarifies that such persons need not have the same cause of action. Thus, where a person dies leaving numerous creditors, any one of them may sue on behalf of himself and other creditors, or any one taxpayer may file a suit against a municipality on behalf of himself and other taxpayers to restrain the municipality from misapplying its funds. The explanation added to the Amendment Act of 76 clarifies that such persons need not have the same cause of action. Again, it is not necessary that the interest must arise from the same transaction, even if the persons who are represented in a representative suit have separate causes of action, or there are separate transactions. A suit under Order 1, Rule 8 can be filed if all of them have the same interest. Explanation to Rule 8 of Order 1 as inserted by the CPC makes it clear that the person need not have the same cause of action. In a statement of object and reasons it was stated, Rule 8 of Order 1 deals with representative suits. Under this rule, when there are numerous persons having the same interest in one suit, one or more of them may, with the permission of the court, sue or be sued on behalf of all of them. The rule has created a doubt as to whether the party representing others should have the same cause of action as the persons represented by him. The rule is being substituted by a new rule, and explanation is being added to clarify that such persons need not have the same cause of action. In Tamil Nadu Housing Board versus T.N. Ganapathy, residential buildings were allotted by the Housing Board to the applicants who belonged to the low income group. After settlement of price, excess demand was made by the board. The allottees challenged the demand by filing a suit in a representative capacity. It was contended that such a suit in a representative capacity was not maintainable, as separate demand notices were issued against each of the allottees, giving rise to separate causes of action. Negativing the contention, the Supreme Court held that all of them had the same interest, and therefore the suit was maintainable. Permission by court. The third requirement for the application of the rule is that the permission of the court is necessary. Permission must have been granted or the direction must have been given by the court. If this essential condition is not fulfilled, the suit does not become a representative one. The court has discretion to grant permission to a person to sue in a representative capacity. It cannot, however, ipso facto, grant such permission merely on the basis of averments made in the plaint. In deciding whether such leave is granted, the principal consideration that should weigh with the court is whether it is satisfied that there is sufficient community of interest as between the plaintiffs or the defendants, as the case may be, to justify the adoption of the procedure laid down in Rule 8. The proper course is to obtain permission before the suit is filed, but it may be granted after filing the suit or even at the appellate stage by allowing amendment of the plaint. Where a plaintiff intends to sue on behalf of others, it is the plaintiff who should apply for leave. Where numerous defendants having the same interest are sued, it is sought to be defended by one of them or behalf of others. Such application should be made by the defendant. Such permission may be expressed or implied or may be gathered from proceedings of the court in which the suit is filed. Under Subrule 1b, there are numerous persons having There are numerous persons having the same interest in the suit. The court may direct that one or more of such persons may sue or be sued or may defend such suit on behalf of and for the benefit of all others who are so interested. Notice, as stated above, where a person sues or is sued or defends the suit on behalf of himself and others, any decree that may be passed in the suit is binding upon them, unless such a decree has been obtained by fraud or collusion. It is therefore absolutely necessary that the notice of the suit should be given to all parties. It is therefore absolutely necessary that the notice of the suit should be given to all parties who would be bound by the decree, for otherwise a person might be prejudicially affected by such decree even though he was not on record and not aware of the suit. The issue of notice of the institution of the suit is thus peremptory, but if it is not given, the decree will bind only those persons who are on record. It is the duty of the court to take care that proper notice is issued which would provide sufficient information to the persons interested in the suit so that they may apply for becoming parties to the suit. It is also the duty of the court to see that the notice is published in a newspaper which the persons interested are likely to be read. This is particularly necessary in view of the fact that the decision in the representative suit becomes res judicata not only against the persons who are on record but also against them who are not on record and yet covered under this rule. Title: Where the suit is filed by or against persons in representative capacity. The fact should be stated in the body of the plaint as well as in the title of the suit. The title of the suit where the plaintiff sues in representative capacity is as follows: A.B. on behalf of himself and the plaintiff and all other creditors of C.D. versus C.D. defendant. Addition and substitution of parties. Sub-rule 3 of the Rule 8 provides that any person on whose behalf a suit is filed or defended under Sub-rule 1 may apply to the court to be added to the party to the suit. Such person must show that the conduct of the suit is not in proper hands, that his interest will be seriously affected to his prejudice if he is not joined as a party to the suit. The reason is that considerable delay may be caused in filing a fresh suit by such party and the cost of litigation will also be increased. Such application must be made without delay. Such a person can only be added as a co-plaintiff or as a co-defendant, but cannot be substituted for the original parties. But Sub-rule 5 as added by the Amendment 76 now provides that where any person suing in a representative capacity or defending a representative suit does not proceed with due diligence in the suit or defense, the court may substitute in his place any other person having the same interest in the suit. Rule 8 is mandatory, must be complied with. A suit filed without complying with the provisions of Rule 8 is not maintainable. Likewise, a decree passed in a representative suit without observing the conditions prescribed in Rule 8 will not bind the persons represented in the suit, though it will bind the persons joined as parties. Withdrawal or compromise. Under Sub-rule 4, no part of the claim in a representative suit can be abandoned under the Sub-rule 1 and no such suit can be withdrawn under Sub-rule 3 of Rule 1 of Order 23. And no agreement, compromise, satisfaction can be recorded in any suit under Rule 23, Rule 3 unless the court has given at the plaintiff's expense notice to all persons so interested in the manner specified in Sub-rule 2, either by personal service or by public advertisement. Similarly, Order 23, Rule 3b, as inserted by Amendment 76, provides that no agreement or compromise can be entered in a representative suit without the leave of the court. Rule 8a empowers the court to permit a person or a body of persons interested in any question of law in issue in any suit to present his or her opinion before the court or to take part in proceedings in the court. The power is discretionary and hence a person or a body of persons, even though interested and concerned with a question of law arising in a suit, cannot claim to present his or its opinion or take part in the proceedings of the suit as of right. Under Rule 11, the court may give the conduct of a suit to such persons as it deems fit, while Rule 12 provides that the plaintiffs or the defendants may authorize one or more of them to appear, plead and act for them. Decree. A decree passed in a representative suit is binding on all persons on whose behalf or for whose benefit such suit is instituted as defended. It also operates as res judicata. Res judicata, explanation 6 to section 11, deals with the representative suits. It states that where the representative suit has been filed, has been decided, such a decision would operate as res judicata against all others. Abatement. In a representative suit, the persons appointed to conduct such suit are merely representatives of other parties who are constructively parties to the suit. Hence, even if any person dies, and such suit will not abate. Another person or the persons interested in the suit may proceed with the suit or may apply to be added as plaintiff or plaintiff's costs. In a representative suit also, parties on record may be made liable to pay costs. In exceptional cases, however, even unrepresented parties, that is, parties not on record, may be directed to pay costs to the other side. In appropriate cases, the court may direct costs to be paid out of property belonging to the community represented in the suit. Execution. A decree passed in a representative suit can be executed like any other decree passed in a regular suit. It can be executed against the persons representing and who are parties or nominee, as also against the persons represented to parties on record. Frame of suit. Order 2. Inclusion of whole claim. Rule 12. Each suit must include the whole of the claim of the plaintiff's claim in respect of the cause of action, and as far as practicable, all matters in dispute between the parties be disposed of finally. Representative suit అయిపోయింది కదా. Representative suit over. Let us stop.